One of the most important laws protecting whistleblowers from retaliation in California is California Labor Code Section 1102.5. And even though many people out there are familiar with this law, quite a few people and even quite a few attorneys do not quite appreciate how powerful and how advantageous this section can be to an employee who was a victim of whistleblower retaliation and who is thinking of bringing a claim for retaliation, wrongful termination, and so forth under this section. And the reason they don't have a good knowledge of the section is because they never bothered to read it in its entirety and fully understand it. I'm not going to analyze the whole section today, but I'm going to talk about a few specific, very important parts of this section that make it so powerful. Now, because this law is so complicated and convoluted, I suggest that you actually pull it up on your computer and you look at it together with me when I'm reading it and when I'm talking about it, so that it makes more sense to you and makes it easier for you to understand which language I'm referring to and why. So, I'm going to focus on just subsection B of 1102.5. And that section says as follows. So, I'm reading 1102.5 subsection B only. An employer or any person acting on behalf of the employer shall not retaliate against an employee for disclosing information or because the employer believes that the employee disclosed or may disclose information to a government or law enforcement agency, to a person with authority over the employee or another employee who has the authority to investigate, discover, or correct a violation or non-compliance, or for providing information to or testifying before any public body conducting an investigation, hearing, or inquiry if the employee has reasonable cause to believe that the information discloses a violation of state or federal statute or a violation of or non-compliance with a local, state, or federal rule or regulation, regardless of whether disclosing the information is part of the employee's job duties. Whew. Okay, so let's talk about some of the key language here that's very important to know for every employee and every attorney who is planning to file claims for retaliation under this section. The first part that I would like to discuss is this. Believes that the employee disclosed or may disclose information to a government or law enforcement agency to a person with authority over the employee or another employee who has the authority to investigate, discover, or correct a violation. Many people out there, and quite a few attorneys, believe that you can only make a claim for whistleblower retaliation if the complaint was made to an outside agency such as OSHA, IRS, and so forth. And that's just not true. The law says that you're protected if you complain to another employee who has an authority over you. And who has the authority over you? Your manager. So if you complain to your manager about any kind of violation of state or federal law at your workplace, you will be protected as a whistleblower. That could be complaining about your company engaging in a potential tax evasion or certain safety violations or maybe some financial improprieties and so forth. You're protected if you complain to the person who has an authority over the employee, which is over you, or another employee who has the authority to investigate. So let's say you make a complaint and your company hires an investigator. Maybe it's an outside investigator who was brought just for this purpose to talk to you and to find out what happened, to find out your side of the story. Or maybe it's an internal employee who was assigned to investigate your complaint. If you share with them what you believe is going on, you're protected as a whistleblower. The next very important part is has a reasonable cause to believe. That means you don't have to be right. As long as you have a reasonable cause to believe that an impropriety, that a violation of state or federal law takes place, you're protected. Let's take a simple example. Let's say you overheard a conversation between two VPs where they're talking about a plan to try to avoid paying taxes or to do something else that sounds clearly shady to you and clearly in violation of the law. And you decide to complain maybe to your manager or to complain to an outside governmental agency. Later, it turns out that you were not correct. No violation took place, but you were fired for sharing what you heard with your manager or with someone else, with IRS, with Franchise Tax Board, with OSHA, with whoever else. Well, guess what? You're here protected as a whistleblower because you had a reasonable cause to believe. You overheard a conversation, or maybe you saw a document, or maybe you made your own determination as a professional that some kind of violation of state or federal law takes place. Now, I want to point out, reasonable cause to believe means more than simply making up stories, fabricating, or suspecting without any reason that an impropriety takes place. You have to have a reasonable cause. There has to be something there that would make a reasonable person believe that a violation takes place. And one more part I would like to point out, and that's actually the very beginning of Section B, that can also be useful, especially today in California. An employer or any person acting on behalf of the employer shall not retaliate against an employee. So let's talk about that language, or any person acting on behalf of the employer. Today, so many people work as contractors through a temporary agency that places them to work for their client, for a larger company. So let's say you've been placed as a quote-unquote contractor to work for a larger company who is a client of a temporary agency. And that temporary agency issues you paychecks. They made it clear to you that you're not an employee of their client, you're just a contractor, even though it might not be true because you're a de facto employee, but whatever. And let's say you notice the same impropriety at the company where you're placed. And then you report that impropriety internally or to some governmental agency. That large company goes to the staffing agency and they tell them, hey guys, who did you send to us? This guy that you sent to us is complaining too much. We don't want him anymore. Send someone else to us to work instead. So the staffing agency comes up to you and says, hey, our client is not happy with your performance. You're not a good fit, or whatever other story they're going to come up with. So because this is the only job that we had for you with this client and they don't need you anymore, we can no longer offer you any work, so we have to part ways. Now, the staffing agency is going to think that they're not really your employer, you weren't performing services for them, and therefore they're not on the hook for that kind of retaliation. But guess what? Chances are that they're out of luck under this section, because this section says any person acting on behalf of the employer. Where, well, surely here it looks like at least one of the two were acting on behalf of the other. Either the client was acting on behalf of the staffing agency, or the staffing agency was acting on behalf of the larger client who was not happy about your complaints, or maybe both. Someone here under this law has to be liable. And that's yet another huge point, huge power of this law, of this anti-retaliation law, that's more relevant today than ever, because again, so many people are employed today as contractors, especially in Silicon Valley, in various technology companies, and where it's so common for staffing agencies and for their clients to try to insulate themselves from liability. This law, 1102.5, makes it much more difficult for at least one of them to avoid liability for whistleblower retaliation if they in fact engage in it. And if you have any other questions about this specific section, 1102.5, or any other questions about retaliation at workplace, you're welcome to email me at arkady@arkadiylaw.com. Thank you.